Wow, are we the people or what? So my name is Janice O'Mahony, and I want to welcome you to the first of 3 lectures on the U.S. Constitution. It is amazing to see so many of you here tonight to deepen your knowledge of this foundational document. I'd like to start by giving some thank yous. In putting this together, many people offered encouragement and help, but I'd especially like to thank Nancy Nordoff, my hero, WICA board members Deborah Campbell and Judy Morton, Barbara Seitley and the Whidbey Island League of Women Voters, Doug Kelly and the Island County Bar Association, starts to sound like rock bands now, Marty Anamarosa and Snow Isle Libraries, Skagit Valley Community College, my great friends Margaret Anderson and Bob Walters, and the amazing staff at WICA who have been nothing but calming and helpful in all of this. Thanks also to Maureen Murphy of Bayview Farm and Gardens who gave us these beautiful plants, and not gave, on loan. They'll be back. And finally, thanks to my husband Mike, my rock. So tonight's lecture will cover the history and content of the Constitution, laying the groundwork for the second lecture on June the 12th, which will focus on the Supreme Court. The final one on June 25th will consider current constitutional issues, challenges, questions. Andy has shared with me that he has not written that one yet because it's right. It's only the times they are a-changin' every single day. So our lecture tonight will be 50 or so minutes. After that, we'll take a 5-minute stretch, so any of you who would like to slip out can do so. But come back because our question and answer period is going to be moderated by Barbara Seitley of the Whidbey Island League of Women Voters. To set the stage, I'd like to paraphrase from the great writing of historian David Fisher. We Americans are a bundle of paradoxes, mixed in our origins, and yet one people. Nearly all of us support our system of government, but we argue passionately, sometimes violently, about its meaning. As Gunnar Myrdal observed in 1942, America is conservative in its fundamental principles, but the principles conserved are liberal, and some, indeed, are radical. Our diversity as a people has created a dynamic tension within a single system. We hold different ideas of liberty within a common cultural frame. The most important fact about American liberty is that it has never been a single idea, but a set of different and even contrary traditions. This diversity of views has created a culture of freedom which is more open and expansive than any one tradition could possibly be. In time, this plurality of freedoms may prove to be our nation's most enduring legacy to the world. Finally, before I introduce our speaker, I have a request. Looking around, I see people who hold many different political points of view. I recognize the possibility of the passionate arguments to which Fisher referred. But I also recognize the strength of our diverse points of view bring to our nation, as he also notes. So we've all come together tonight to become better informed citizens. Let's be kind and neighborly to each other so every opinion can be safely expressed and any question is okay. We can respectfully listen to each other and we can learn together. Now, it is my great pleasure to introduce Associate Professor Andrew Siegel of Seattle University Law School. Andy earned his BA in history with highest honors from Yale, his MA from Princeton, and his law degree, again with highest honors, from New York University School of Law, where he graduated first in his class and served as executive editor of the Law Review. Please help me welcome Professor Andrew Siegel.
Thank you all so much. It is absolutely a pleasure to be here. I wouldn't want to be anywhere else, to see all the faces, to talk to the community. It is absolutely the best thing about my wonderful job that I do get to talk to so many different people, community organizations, judges, lawyers all the time. The task here is broad. We have 3 lectures, and I'm going to tell you about them in a minute. Could take up 3 hours of your time. More than that with questions, but I'm sure I'll leave a lot on the table. So if you have other questions for me, other issues you want to discuss, we'll use the question period. We'll talk afterwards. I have to begin by thanking Janice. I cannot believe, I assumed when she approached me about this that there was some well-formed committee, some long-standing organization. Only after I had accepted it and started digging in the details did I find out that she's doing this from her kitchen table with the help of a couple of people. So the fact that she pulled us. My longtime colleague, Paul Holland, connected me with Janice. He'd worked with her in the past, and I thank him for this opportunity. As Janice told you, she told you about my educational background. I also bring to the table some experience as a Supreme Court law clerk, which we'll talk about in the second lecture, and a lot of years of teaching in this subject. But it's important to understand as we get into the lecture today that I am a lapsed historian. I'm a trained amateur, right? All but dissertation, switch to law, teach constitutional law. My work has always been historically inflected, and you're going to get that theme running through. We're not just going to talk about the words or today's cases. As you probably know, the first lecture tonight is about the Constitution, its history, and its text. You've heard about the second and the third. Tonight's the drier lecture. On the 12th, we're going to get photos of old judges in wigs and lots of gossip about the justices who wouldn't talk to each other and all that good stuff. And then on the 25th, right, we're going to be we're going to hear audio from oral arguments. And we're going to have tweets up on the board and all that kind of stuff. Tonight, this is our only prop, right? The Constitution of the United States. When I told Janice this, she said, okay, well, why don't you tell them that tonight they eat their vegetables so they can have dessert later? Which is funny, but not really what I want to convey, because I hope we have more fun than that tonight. I also, more importantly, don't want to overpromise for the later lectures. So we'll see how we go. Tonight, the structure of our lecture is pretty straightforward. I want to spend the beginning of the lecture narrating and talking about the events from before the Revolution through the adoption of the Bill of Rights in 1791. And then I want to spend the rest of the lecture talking about American constitutional history and American constitutional law by actually going through the text. In order. We're not going to talk about every provision. We'll flag some for the future. We'll skip some entirely. But we'll say something about a lot of the important ones and focus in on the most important ones. So we begin on the path to Philadelphia. The US Constitution is over 200 years old. It was drafted in 1787 and adopted in 1789. In many ways, however, the drafting and the ratification of the US Constitution was as much an end as a beginning, the culmination of a dozen years of constitution making in British North America, and an even longer period of reflection on how best to structure government and society to manage both liberty and order. The coming of the revolution is a story of constitutional ideals. As the Harvard historian Bernard Balin wrote, in a book that is now shockingly 60 years old, The Ideological Origins of the American Revolution. The revolution was, in a fundamental way, a revolution of ideas, fueled by the notion of liberty, focused on the proper bounds of government, coming out of the classical Republican tradition that thought that liberty was precious, that liberty degraded quickly, that corruption came quickly to government, that we had to be careful about how to structure our government. The coming of the revolution was the story of a people who saw declining respect for the rights and the privileges and the prerogatives of Englishmen, in a series of escalating abuses, all those famous acts that no one, including me, can keep straight, right? The Sugar Act and the Stamp Act and the Tea Act and the Townsend Act. The late historian Pauline Maier nicely encapsulated or summarized this whole process of getting ready for revolution when she talked about how there was a generation of Americans who were really upset, but they were fighting for reforms within the British government. Then there was a generation of Americans after that, or half a generation of Americans, who wanted a revolution, but the revolution they wanted was an English revolution. They conceptualized themselves as Englishmen. They wanted fundamental change in the English system. And then finally, gradually, the idea of an American revolution, a distinct people, came to mind. After the revolution, this process continued. The great historian Gordon Wood, in his book, The Creation of the American Republic, picks up the story here, talking about how the experience of drafting state constitutions, governing under state constitutions, was this grand experiment for a people who'd fought a revolution, at least partially over ideas. They got an opportunity to work out the implications of those ideas for actual governance, to see what worked and what failed. And believe me, most things failed in that time frame. At the heart of this is a commitment to constitutionalism. And that's kind of makes sense. We're talking about the Constitution. But it's one of the defining characteristics, maybe the defining characteristic of American national politics, some would say American national character, is a commitment to constitutionalism. The desire to lay out and to understand the basic rules and principles which are going to govern social and political interaction, combined with the belief that the members of society have the authority, indeed the obligation, to enter into such an agreement. During the last decades of the 18th century, everybody made constitutions. Not only did we see the federal constitution, 2 of them, not only did we see a whole bunch of state constitutions, which we're going to talk about, but towns made constitutions, counties made constitutions. Every time a group of people came together in a society, they made constitutions. Probably the most interesting story is a document found by the historian Bruce Mann. Bruce Mann, probably more famous today as the husband of Elizabeth Warren, but in his own prior and current career, one of the leading historians of, the leading historian of American bankruptcy law and one of the leading historians of American corporate law. And in doing some research for a book, he found documents which were the Constitution that a whole bunch of Americans who were held in debtor's prison drew up for how they were going to govern the debtor's prison in this time frame. And it's the same themes, and it's the same ideas, and the belief that you can only govern through written law arrived at by the people. This was new in the world at the time. It differed from England and the rest of the world up until that point. Now, there's a great academic discussion. In fact, there's an entire academic course, and I've taken it back in college, about the sources of this constitutionalism, where it came from. And I can't do much more than list some of the things to think about, some of the ideas, but it's worth going through quickly. Britain, England, even though they didn't write it down, even though their idea of a constitution was very different, they talked about their constitution a lot, and that was a starting point. The Republican thought, these ideas about liberty, the experience of old republics like Rome and some of the Greek republics, that's another part of the story. But you add to that the experiences on the American continent, experimentation with various models of British constitutional thought, the need to design institutions from the ground up, The utility of written agreements and written documents in skipping over centuries of accretion. I mean, England built its constitutional tradition through practice, through trial and error. America had to get there to the institutions quickly. Written documents and actual overt debate on the contents of the institutions was a useful substitute. The experience dealing with an overreaching empire and the difficulty of formulating arguments to justify what they knew in their hearts, that it was improper what England was doing, created a lot of American constitutional thought. Natural law theory, social contract theory, people like John Locke. Puritanism had something to do with it in its contractual nature, its reliance on signed agreements. Probably the most interesting experience was the experience with colonial charters. Colonial charters, when they were granted, were documents guaranteeing the rights of stockholders or proprietors. They were corporate documents. But they laid out rights in detail and structures in detail, and they were ultimately transformed in the colonial era into fledgling written constitutions. So through some combination of those and other influences, we locked in on the idea of a written constitution. Now, I didn't plan this, but the Constitution that you have here also has the Declaration of Independence in it. The Declaration of Independence is not formally a constitution. It never created a nation or the rules for a nation or anything like that. But it echoes the language of constitutionalism. It's a proto-constitution in a lot of ways. It states a constitutional theory in its famous beginning. It is, in fact, the coming together of people to alter and then explain the change in their government organization. It includes an indictment of the king for crimes against the British Constitution. And it contains a broad declaration, a kind of proto-Bill of Rights. So there are constitutional elements there. In the immediate aftermath of the Revolution, not the aftermath, in the aftermath of 1776 and independence, the states began making constitutions. Between 1776 and 1780, every state, with the sort of exception of Rhode Island and Connecticut, which we'll get to in a minute, adopted at least one constitution. South Carolina and New Hampshire adopted two. They didn't like their original ones. And a bunch of states, most notably Massachusetts, had to draft more than one to get one accepted. And we'll talk about those experiences. Rhode Island and Connecticut, what they did was they liked their royal charters very well. They just didn't like the king. So they kept the royal charters, and everywhere where it said the king or the crown or Britain, they just crossed it out and they wrote the people or something like that. Quite literally. Connecticut didn't make a constitution until 1819, and Rhode Island even later. There were two waves of constitutions. The first wave, through early 1777, so very quickly, was extremely democratic. Tended to have the direct election of at least one, usually both houses of the legislature, pretty broad suffrage in comparison to what happened before, a weak executive and a judiciary, if it even had those, both heavily dependent on the legislature with little separation of powers. They wanted the people to rule fairly directly. No veto, term limits for the executive. See, they didn't like kings, so they were making it as far from a king as possible. Strong bills of rights. Though they hadn't figured out what a Bill of Rights was, so there were strong Bill of Rights, but they were alienable by the legislature. So strong statements of rights, but again, sticking with democracy, the legislature could really do what it wanted. Jury rights and religious liberty in most of the state constitutions were not alienable by the people, which is interesting. They were drafted by the legislature, the existing legislature, primarily amendable by the legislature. Pennsylvania had the most democratic constitution, a constitution that was so democratic that they rotated through pretty much every shopkeeper in Philadelphia as a member of the legislature at some point in, and Virginia had the first significant Bill of Rights. Pushback, too democratic was the consensus, and a second wave of constitutions started in late 1777. Still very democratic, but more interested in balancing power, experimenting with separation of powers, as we'll talk about. A stronger executive, a more formal separation of powers. Drafting and amending by conventions rather than by the legislature. You begin to see the second house of the legislature as representing some sort of different interest, whether it's property or expertise, rather than just another popular branch. These state constitutions were really important for a future federal constitution. in terms of showing the importance of separation of powers, showing the possibility of dividing authority between different levels of government, which made federalism as well as separation of powers possible, as we'll talk about. The need for a Bill of Rights, although the convention initially muffed that one, and we'll talk about that. The idea, and this comes mostly from the Massachusetts experience, the idea that a legislature shouldn't be creating its own constitution, that a legislature is a creature of a constitution, not something before a constitution. So a convention of the people has to draft a constitution, and then you don't submit it back to the legislature for approval, you submit it to more conventions. The people, in as democratic a process, which is the process that was used for the Constitution, the need for popular ratification. Through the early period, the national government was governed by our first Constitution, the Articles of Confederation, adopted by the Continental Congress very quickly. Its defining characteristics are quite different than what we live with now. A unicameral legislature, one chamber, where each state had one vote. You could send as many representatives as you wanted. You were paying their salaries. The federal government wasn't. But they only got one vote collectively, just like at the Constitutional Convention. No federal executive. Any execution that was necessary was done by a committee of the legislature. You can imagine how that worked. No federal judiciary. You relied on the state judiciary to enforce the federal Constitution. Again, you can imagine how well that worked, right? 9 states needed for most legislation. No power to directly assess taxes. You had to ask the states directly. You had to ask the states for the money. They didn't have to give it to you. States had the power to impose tariffs on goods coming from other states. And there was no power to compel states to follow any sort of legislative mandate. You wanted to change all this because it wasn't working? Amendments had to be unanimous. You can see how well that was working. It proved to be too weak. It had some strengths. It passed the Northwest Ordinance, which was a very useful blueprint that we've used ever since about how to admit more states and more territory without having the existing states fight about it. And as the historian Leonard Levy said many years ago, it really was an indispensable transitional stage. But it proved to be too weak. Most importantly in foreign affairs, probably, no ability to negotiate treaties, to enforce the peace agreement, the inability to enforce its will, no executive or judiciary, famously powerless during the Debtors' Rebellion led by Daniel Shays in Massachusetts. A single state could wreak havoc, could block amendments, impose duties that thwarted a coherent commercial policy, block the enforcement of contracts and the collection of debts. Both the Virginia courts and the Rhode Island legislature were experts at that. Rhode Island passed statutes saying, we're creating this basically worthless paper money, and all merchants have to accept this for all debts. So you can imagine how well the out-of-state merchants took to that. And there was no money. There was no money being coined by the federal government. So each state had its own. I was just in Philadelphia with some of my younger kids and saw this wonderful exhibit of all the different monies that were being used by the different states in this time period. So a bunch of leading citizens in New York and Virginia and a few other mid-Atlantic states substantially changed the document. They felt there was a need to do so. What were their reasons? Well, the articles were really weak. The amending process, the lack of a commerce power. They were concerned with the particular policies of Rhode Island and Virginia and the other states that were thwarting national commercial policy. These were mostly revolutionary veterans, concerned that the opportunity for forming a national unified nation was slipping away, and also a sense that the government structures were out of whack. These were conservative men, for the most part, merchants, wealthy men, who thought that it was tilting too much towards democracy. So all of that was in play. In 1786, they called a convention in Annapolis, Maryland. 6 states showed up. The big coup was General George Washington came, giving his imprimatur to the whole process, to the sense that we needed major amendments. Convention was a success, but a limited success. They realized that there was little that they could do, but that there was just 6 states present, but that there was a sense that they should meet with all the states. So they called a convention in Philadelphia for the next year. It was a very popular call throughout the country. Congress, sensing that that's the way the wind was blowing, endorsed their call, and the convention was called in Philadelphia for the summer of 1787 to propose amendments to the Articles of Confederation. So they get to Philadelphia. Eventually, every state but Rhode Island shows up. Yes, Rhode Island called during that period Rogue Island by many a conservative. It's an all-star roster, right? Jefferson and Adams are off in Europe, but pretty much everyone else you've heard of from this period is there. Washington, Ben Franklin, who's the oldest delegate, James Madison and Alexander Hamilton, who are two of the youngest delegates, other famous fathers who are lost to time more, like James Wilson and Gouverneur Morris. They were supposed to propose amendments, but before everyone had really arrived, about half the states are represented, they took a vote, and they decided that the first amendment they were going to do was they were going to look at James Madison's plan for a whole new government, the Virginia Plan. So from the very start, their amendments were a plan for a new government. And others came with a plan. They debated a variety of plans. They worked off the Virginia Plan. There were lots of rival plans, lots of division, lots of different interests. You can guess what the major axes of division were. Most famously, perhaps, large states versus small states. How do the large states get their interests sufficiently taken care of? How do the small states not get eaten up? Equally famous, probably, free states versus slave states, or states that were dependent on slavery versus states where slavery was on its way out. It's probably a more accurate way to describe that. How much would they protect, respect, enshrine that peculiar institution? Advocates of a more democratic system versus a more balanced system. The convention almost broke down many times. Ultimately, it was saved by a spirit of compromise. Maybe it was the wisdom of the founders, maybe it was necessity, maybe it was luck, but all but four of the people in attendance at the end decided that it was better to sign than not to sign, to go with what they'd agreed on. And we're going to look at many of the dozens of big and small compromises in the document in just a few minutes. The historian John Murren once famously explained that the Constitution was a roof without walls, that there was no American nation, there was no American national identity yet, there was no people that you'd call American, but they built this governing structure for those people in large part that they'd fill in the walls once the roof was there. Similar spirit. Ben Franklin has a famous quote that's at the back of your book here, when it may be true, it may be apocryphal, it doesn't really matter, right? In which Ben Franklin is supposedly asked on his way out the door of the Constitutional Convention, what have you given us, sir? Is it a monarchy? Is it a republic? And the famous answer, which was my Facebook status on Election Day this year, was a republic if you can keep it. And that really was the spirit. We were going to give it a try. It was in the people's hands. The same classical Republican spirit that had motivated resistance to England and the drafting of the Constitution was dubious about our ability to succeed. Ancient republics lasted a generation or two. They didn't last for centuries. Now, James Madison, Alexander Hamilton, some of the forward-looking founding fathers had ideas of things you could do to try to entrench it, to make it last longer. But there was a great deal of skepticism. Thomas Jefferson, who was not there, was perfectly in favor of the Constitution, but thought it didn't matter that much because we'd have a new one in 20 years, and thought that was the way the constitutions worked in republics. Okay. So they gave us this document. What'd they put in it? The main features first, then we'll pull out the document, right? They gave us a new national government sent to the people for ratification. They gave us a bicameral legislature with two chambers. Two chambers for a variety of reasons, but one of them is to compromise on representation. States are represented in the Senate, people, population in the House. The so-called New Jersey Plan. Big states took a long time swallowing this one, but ultimately they did as the price of the Union and for some of the other things. A relatively strong executive, not nearly as strong, and we'll talk about this as has come to pass, but a comparatively strong executive to balance the legislature with specific checks and balances. A commitment that there would be a federal judiciary, although again, as we look at the text, you'll see no commitment to what it would be. The Constitution says there has to be a Supreme Court. Doesn't say anything about lower federal courts or about the makeup of the Supreme Court. Leaves that to the political process. That's known as the Madisonian Compromise. Compromise on methods of election for all branches. Somewhat democratic, but not, people have a role in just about everything, but not directly democratic in very many places. Enumerated rather than general federal legislative powers. Powers over taxation, to regulate commerce, foreign affairs, but no general federal legislative power. And again, we're going to talk about that for a while. A supremacy clause, federal law, supreme, we'll talk about that. A compromise or postponement of the slave question. The document acknowledges the existence of slavery, protects it in a variety of specific ways, like prohibiting Congress from banning the importation of the slave trade until 1808, but doesn't fully enshrine it in the document, leaves space for further political development, very much a tortured compromise. Again, we'll talk about that. And in a rare mistake, very few individual rights provisions. Despite the fact that they learned a lot of the lessons of the state constitutions up till that point in time, they didn't feel a need for a Bill of Rights. Now, the reasons for that are complicated. On the one hand, there was a genuine fear that if you wrote down some rights, you'd be saying that other rights didn't exist, and people thought there were lots of natural rights. To some extent, they thought, in a kind of category mistake of 18th century political thought, that if you have a government of limited powers, you don't need a Bill of Rights because it doesn't have the right to infringe on, it doesn't have the power to infringe on those rights. Doesn't even make sense to us today, but hundreds of really smart people wrote thousands of pages explaining why that was true. I have always suspected that the main reason was that the Constitution had already that the convention had almost broken down so many times, was basically out of time, and a debate on what the contents of individual rights would be were simply not on the table. There wasn't enough time. They knew that the convention would break down, but they sent it out without a Bill of Rights. Now, they sent it out with its own ratification language. They said we only need 2/3 of the states for ratification. The articles had said everybody had to amend. At its beginning, this is a creation of a new government, arguably illegal, arguably in violation of the existing law at the time. And as we'll see at several crucial times in American history, when we remake the Constitution through this kind of meta-political process, through this national conversation, we don't always meet with the niceties of the pre-existing constitutional structure. Ratification was a unique idea, the idea that people were forming their own government. And it was taken seriously. There were heretofore unknown levels of political participation, more voters on the Constitution than on anything else in the history of democracy. A raging debate in the popular press. What we've come to know as the Federalist Papers were 85 newspaper essays written in New York by Jay Madison and Hamilton to sway people. They were propaganda. They were brilliant and sophisticated, but they were political propaganda. There was a strong anti-ratification movement that popped up, focusing on threats to individual liberty and the potential for despotism. The nation was essentially evenly divided. Though 11 of 12 states ratified, that was not a foregone conclusion. North Carolina rejected. Rhode Island wouldn't even vote, didn't come to the convention. Ratification ultimately came down to very close votes in the 3 biggest states, Virginia, New York, and Massachusetts. And even though mathematically you only needed 2, effectively you needed all 3 if you think about the geography of the country to make the country work. It passed in all 3 by small margins. In Massachusetts, 187 to 168. Virginia, 89 to 79. New York, 30 to 27. Ratification in these states came only after the supporters of the Constitution agreed to draft a Bill of Rights at the first Congress. So James Madison went to the House of Representatives as a representative. Probably could have had a more prominent place if he wanted. with the sole goal of drafting a Bill of Rights based on suggestions from the states. The House passed 17 amendments. The Senate's passed 12. The states at the time ratified 10, although, as we'll talk about, an 11th of those original amendments was ratified in 1992, becoming the 27th Amendment. So the Bill of Rights, since it was part of the original set of compromises, is usually taken, and I think rightfully, to be part of the original Constitution for all practical purposes. I promised I'd get us to the ratification of the Bill of Rights. We are there. And now we'll look at the document itself. Feel free to follow along, but the couple of times where the language is really necessary, I'll quote it to you. Article 1. Article 1 is the part of the Constitution that lays out the legislature and establishes our system of federalism, a division of power between the states and the federal government. Federalism is the idea that there are two coexisting systems of government, levels of government, authorities, and that they each have their unique sets of power. They have complicated interrelationships, and there are rules for governing disputes between them, but both are operating in some way, shape, or form as a sovereign. One is not a subsidiary of the other. Local governments are, for the most part, for example, under American municipal and state constitutional law, fundamentally entities of state governments. States are not entities of the federal governments. They're unique sovereigns. So one of the first questions we ask in common law, one of the first things that students learn and feel proud about learning, right, is why the lesson, the first chapter or second chapter in the course, is both the chapter on the scope of legislative power and the chapter on federalism. And the answer is that it is in discussions about the limited but significant powers of Congress that most of the disputes about federalism and most of the line drawing about federalism have taken place. The legislature is first on purpose. It is expected, assumed, no one ever thinks differently, that this is going to be the most powerful branch. It was the only branch that existed beforehand. And in most democracies that had existed, or republics that had existed at that time, it was the legislature that most of the focus was on. Section 1 announces bicameralism, the idea that there'll be two houses. England had two houses, but that made sense because England had different orders, right? You had a House of Commons and a House of Lords. Adapting that to the American continent was complicated. Some states tried unicameral legislatures. Most settled on having a second house for balance, but they couldn't really figure out who it was representing. Property and expertise might be represented, but not in a formal sort of way. Ultimately, the idea that you could get a better sort of people in a smaller house with different deliberative procedures convinced the delegates, along with the idea that, as I said, you needed two houses to balance the small states and the large states and make both of them satisfied. So a bicameral legislature gets worked into the document. Sections 2 through 4 talk about the makeup of the House and the Senate and the qualifications. Again, states are represented in the Senate, people in the House. You have somewhat higher qualifications for the Senate, smaller, more refined, more deliberative body. You have the infamous 3/5 clause, the compromise by which non-free people, and they're referred to in some sort of euphemistic way, non-free people are counted as 3/5 of a person for the purpose of calculating representation in the legislature and taxation. Now, you think of people being treated as 3/5 of a person, and you assume that the progressive alternative was to treat them as a full person. And in a moral sense, it was. But in these particular clauses, the progressive position was actually not to count the non-free people for the purpose of representation, because to the extent that you were giving any vote in terms of population to people who could not themselves vote, what you were doing was giving more power to their oppressors. So there was a lot of back and forth, and it was never really on the table, though the South asked for it, to count slaves fully in the population assessment. Symbolically, the imposition of a fraction has done a lot of weight politically to kind of stand in for all the many horrific compromises with slavery that are in the Constitution. Some powers are reserved to one chamber or another based on their role. The House impeaches, the Senate tries. The Senate has the power to confirm, advise and consent and confirm nominees, treaties. The House must originate revenue bills. There are a lot of little compromises baked in that kind of the advanced course might focus in on, right? For example, one of my favorite compromises that no one ever talks about is they couldn't agree on how broad the suffrage would be for the House of Representatives. So if you look at the text of the Constitution, what it says is, in each state, whoever can vote in the election for the larger house of that state legislature can vote in the election for Congress. They kick that to the states. So if you have property qualifications for your state legislature, you can use it for Congress. Revenue bills have to originate in the House. Originally, they were unamendable in the Senate, but the compromise is they have to originate in the House, but now they can be amended by the Senate. Lots of things like that. Section 7 is the veto. Controversial at the beginning, but ultimately supported by most, deemed necessary to prevent despotic legislatures as they begin to work through the idea of checks and balances. Section 8 is the enumerated powers of Congress, Article 1, Section 8. For many people, particularly those who like the structural parts of the Constitution, this is the most important part of the Constitution. State legislatures and most other national legislatures have what's known as plenary powers. They can legislate on any subject. Some places they can legislate on any subject as long as it's for the health, welfare, and morals of the people or something like that. But the idea is that you have the ability to pursue the general welfare through any kind of legislation, any subject. Madison wanted it. Many of the big state folks wanted it. The nationalists wanted it. But they weren't going to get their way. So they worked out a compromise after the convention rejected that. What we have is a system of dual sovereignty in which the federal government has substantial legislative powers, much more than they did under the Articles of Confederation, and its law is supreme in those areas. It supersedes conflicting state law. It doesn't have to negotiate with state law. But those areas are limited, and states retain primary authority in other areas. The key powers, the power to tax and spend, the power to borrow money, to regulate interstate commerce, to regulate immigration, to coin money, to establish a post office, patents, copyrights, bankruptcy, to raise, pay for, and regulate a military. That's broad, but it's not unlimited, right? A lot of things you can think of that don't fit. No environmental power, no civil rights powers, which become important. The key principle, as Neil Siegel, a scholar at Duke, wrote a few years ago, the key principle is that the powers that are listed there are the things that the states can't do individually, that need to be done collectively. And there's an interesting constitutional question that's long hung over the document, whether that should be an interpretive principle. That in general, in interpreting the scope of Congress's powers, whether Congress should have leeway to do things that are hinted at or not specified to the extent to which you're in an arena in which you need to act collectively, where individual regulation won't work. And conversely, whether it is an argument against an exercise of borderline power that it could be regulated differently in the various states. There's also a necessary and proper clause in there at the end of the list of powers. Power to do what's necessary and proper to effectuate the other powers. Added to strike the proper balance, clearly meant to broaden Congress's authority, to make it so that in this general set of areas where Congress needs to legislate, where the national government needs to legislate, we don't get too nitpicky on particular means, on whether something that is necessary for the regulation, for the issuing of, for coining money, for example, but is not itself specified, can be done. Lots of debate from the very beginning with Jefferson and Madison on one side, Hamilton on the other side, about how broad the necessary and proper clause is, whether they're implied powers. Debate focused very heavily on whether Congress had the power to create a national bank, a dispute that went through several cycles before being resolved by the Supreme Court and John Marshall, who we'll talk about in the next lecture, in McCulloch versus Maryland. Marshall gave us a famous test in that case that has been not always followed in spirit, but always quoted and largely followed since then, which is a broad test for the scope of Congress's power. Let the ends be legitimate, so let it be listed. Let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited, but consistent with the letter and the spirit of the Constitution, are constitutional. So basically, Constitution is a list of ends. Congress has an awful lot of freedom when it comes to means. The one power that needs more explication is the commerce power. By far the most important in US history. Three issues. What do we mean by interstate? What do we mean by commerce? And to what extent do we care about principles of federalism in interpreting the scope of the commerce power? Originally broad. What do I got there? Originally broad. John Marshall's famous opinions contemplate the existence of local markets, but a broad national power. But we quickly reach the question, what do you do when the economy becomes interconnected, when transportation and commerce crosses state lines, when there are no local markets anymore? And the Supreme Court has fought in a series of really significant cases throughout American history about, can you regulate homegrown wheat? Can you regulate the wages of local laborers? Can you regulate against segregation through the Commerce Clause? Can you regulate against guns in schools? Some of our most famous decision, and the doctrine has ebbed and flowed. I'm having such a good time in putting in so many details that I am taking up a lot of your time. So we will speed up here. Article 2, the power of the presidency. I think we might want to talk about that sometime during this lecture series. I'll give you a little bit of a preview. The Constitution did not envision a presidency as broad as we got, the imperial presidency. It emerged to fill a vacuum, and we'll talk about that. Article 2 begins by saying the executive power shall be vested in a president of the United States. A key textual dispute in the Constitution between James Madison and Alexander Hamilton, we keep hearing their names, right, is the dispute about what that means. Hamilton argued that the executive power was being granted to the president, and that meant something. That implied a set of powers, privileges, rights that all executives had, implied lots of powers. Madison said, no, that's just how we say we have one president. It doesn't have any meaning beyond that, and the only power the president has are the few that are listed, the commander-in-chief power, pardons, treaties, appointments, to take care that the law be faithfully executed. Hamilton's largely won that battle. The president has gotten stronger, particularly in foreign affairs, but also in the domestic sphere. There have been a handful of cases, and we'll talk about them in the third lecture. See, I'm kicking them over there. In the third lecture about steel seizure and Watergate and the war on terror cases that have established some principles and limits on executive power, but fairly broad, filling in the gaps for the executive. Article 3 is the judicial branch. It's the subject, really, of the second lecture. There was none under the Articles of Confederation. As I mentioned, the Madisonian Compromise said that there has to be a Supreme Court, but Congress gets to decide the details, and that Congress gets to decide whether to have federal courts at all, or whether to just take appeals from the state courts. The first Congress created federal courts, and we've had some ever since, but they've ebbed and flowed in their size and their power. It doesn't specifically mention judicial review. We'll talk about Marbury versus Madison in the next lecture and the coming of judicial review, but there are some strong implications for it in the document. The emergence of the court as a powerful third branch was by no means preordained, but it happened through the will of a lot of judges, a sense of a need for it, and we'll talk about that. Articles 4, 5, 6, and 7, the rest of the Constitution, they've got some interesting stuff. Article 4, for example, has the full faith and credit clause, which says that we need to unify the nation by having certain acts of one state be enforceable in other states, at issue in a lot of different contexts, including the recent marriage litigation. Also has the 2 fugitive slave clauses, probably the 2 worst compromises with slavery in the document, which require northern states, free states, to effectively return slaves that have escaped. Disputes about the enforcement of that leading up to Prigg versus Pennsylvania were some of the big crises that led to the breakdown of the Union. Article 5 has the amendment process. Article 6 has the supremacy clause. Crucially important, the idea that federal law trumps all conflicting state law. The amendments. The Bill of Rights, I told you it was part of the original deal, ratified in 1791. Amendments 1 through 8 lay out specific individual rights guarantees. They originally applied only against the federal government. That was thought to be the need. States had their own laws, their own powers, their own Bill of Rights. After the passage of the 14th Amendment, for many years, the leading issue in constitutional law was whether these amendments should apply against the states as well as the federal government. After a couple of false starts, ultimately, the courts have incorporated not all, but almost all of the Bill of Rights against the states. And that's part of a revolution we'll talk about in a minute. The First Amendment is the famous rights to speech, press, assembly, religious liberty, which I'm happy to discuss in the questions. The Second Amendment, known as the embarrassing Second Amendment, after a law review article by Sandy Levinson. It's embarrassing because, well, I'll get there in a second, but it's an ambiguous amendment that was not historically interpreted to create an individual right. But after a big concerted push led by the NRA and other groups in the 1970s, a number of scholars began to make out a case that it should protect an individual right. And why Sandy Levinson, who's a liberal scholar, calls it embarrassing is a lot of their cites and arguments were awfully good, were good explanations, or were good permutations of arguments for other broad rights, or good historical evidence. And it's actually a close and complicated case, again, happy to talk about, about what you should do with the Second Amendment. In 2 cases, Heller and McDonald, in recent years, the Supreme Court has announced an individual right applicable against the states, but they've left all questions of what that means, what can be regulated, what gun control is legitimate, and all of that. They have left all of those questions undecided and denied cert and left those to the lower courts. One day that'll be filled in, but we have almost no content to our Second Amendment law today. After the embarrassing Second Amendment, we get the irrelevant Third Amendment, which has been cited by one federal court ever, or been relied on by one federal court ever. It's about quartering soldiers in your home in a time of peacetime, not a major preoccupation of even rights groups in the modern world. The 4th through 8th are mostly criminal procedure, some very general, some very specific, things like the rights against unreasonable search and seizure, double jeopardy, right to counsel, the right to confront witnesses against you. Originally, not particularly important because most prosecution took place in state courts and the Constitution didn't apply against the states. But once incorporation came, and once we became kind of the mass prosecution and incarceration nation that we were beginning to become, there was a revolution. It's one of the key aspects of the Warren Court in the 50s and 60s, and we'll talk about that. And these amendments became sort of a federalized code of criminal procedure with pros and cons, again, happy to talk about. The 9th and 10th Amendments are more theoretical. They state structural principles. The 9th is talking about how unenumerated rights belong to the people. The 10th is talking about how powers not listed belong to the states. Huge disputes historically about whether they create their own rights or are just interpretive principles for other rights, but they're at least underlining of core constitutional provisions. In the next 74 years, we get 2 amendments. The 11th Amendment, which overrules a Supreme Court decision, one of 3 that does so, about suing states, citizens suing states, and the 12th Amendment, which is a response to the rise of political parties and the election of 1800, which changes the way in which we pick presidents and vice presidents, running in tickets as they do today. 2 in 74 years. Then we fight a civil war. And it's the last significant thing I'm going to talk to you about, the amendments that come after the Civil War. The Reconstruction Amendments really are, as many people have said, a second founding. We're about to reach the 150th anniversary of the 14th Amendment, and they're getting a lot of coverage. The ABA Journal recently had a huge cover story on the 14th Amendment as a mini-constitution in and of itself. They're passed sequentially in response to civil war and slavery. The 13th Amendment in 1865 outlaws slavery and indentured servitude. The 14th in 1868 protects civil rights, privileges and immunities, equal protection and due process clauses, and the 15th Amendment in 1870 protects voting rights. Lots of dubious tactics used to get them approved. Again, semi-illegal, like the original Constitution. Sometimes they counted the seceded states. Sometimes they didn't count the seceded states. Some states were compelled to ratify some of the amendments to get back in. If they were in already and they weren't ratifying them, they got kicked out until they ratified them. Like the original founding, not strictly legal. As Bruce Ackerman, the Yale historian and constitutional law professor, says, this was a constitutional moment, again, like the original founding. The people coming together to create a new constitutional structure. Chris Eisgruber, who's a brilliant constitutional theorist, who's now the president of Princeton University, when he was a young constitutional law professor, wrote an underrated essay saying that we all live under the 14th Amendment's Constitution. And it's really true. The Civil War and the coming of the Civil War revealed the prior Constitution's flaws, particularly the idea that we let states independently define the rights of their inhabitants. The 14th Amendment changed every significant relationship in the Constitution. It changed the relationship between state and federal government, between the people and the states, between the people and the federal government, between the courts and the legislature. There are bits and pieces there that all reconstituted. Beyond that, it changed the basic nature of the Constitution. This is really Eisgruber's point. Before that, it really was a structure, if you look at what was in the Constitution. Now it's more than that. It's a statement of values. 5 core values or rights, right? Free expression and free belief from the First Amendment. But to that, we add basic protections of equality and liberty and dignity of individuals. It's now a charter of rights. It's a commitment to protect those values against states as well as the federal government. President Lincoln is rightly credited with this from the Gettysburg Address, but the 14th Amendment is part of the same thing. It's a reorientation towards the idea that we're building a single national community dedicated to those values. It's also a recognition that building such a nation is a multi-generational project requiring substantive input from each generation. The language is vaguer, it's broader, it's more aspirational, it's less concrete than the Constitution that existed before then. Living up to these amendments' ideals has been a struggle. Much suffering and dehumanization along the way, often approved by the courts. The initial resistance to the broad protection of civil rights came quickly. The Slaughterhouse case in 1873 effectively took the Privileges and Immunities Clause out of the Constitution. The civil rights cases in 1880 told us that that the Equal Protection Clause doesn't apply to private conduct, putting a lot of stuff out of reach. Plessy versus Ferguson in 1896 famously validated separate and allegedly equal public facilities, validating the Jim Crow institutions, American apartheid that had developed. Michael Klarman, the Harvard historian, has chronicled in a long book the court's terrible record of protecting free blacks after that, protecting civil rights of African Americans going forward for several generations. It took a concerted litigation campaign by the NAACP and Thurgood Marshall, the experience of World War II, shifts in public opinion to win the kinds of victories that have made that amendment have meaning for the African American citizens of this country. And it's taken similar multifaceted political and legal campaigns for other groups to claim coverage under the broad language of the 14th Amendment. Most notably, the movement for women's rights in the early 1970s, litigated by Ruth Bader Ginsburg, and the ongoing battle of many individuals this century for the rights to include LGBTQ individuals fully under the 14th Amendment. So much more to say about that. We'll leave that for questions. I end with a brief and somewhat comical tour through the 20th century amendments. Quickly, the 16th, 17th, and 19th amendments are progressive era amendments that allow an income tax, overruling a Supreme Court decision, popular election of senators, and allow women to vote. The 18th and 21st amendments are the prohibition and the never mind no prohibition amendments. The 20th, 22nd, and 25th are technical amendments, reducing the lame duck period in Congress, codifying the unwritten two-term rule for presidents after FDR broke it, and dealing with vacancies in the vice presidency and providing for presidential disability. That's the 25th Amendment, which you probably never heard of until this year, and we'll talk about it in the third lecture. And then there's the 27th Amendment, which I teased at the beginning, and it's a fun place with which to end. It's one of the original Madisonian amendments. It says sensibly, but rather unimportantly, that no raise that Congress votes itself can go into effect until there's been an election. Ratified by a few states, never quite got there. Ratified 202 years after it was submitted to the states, finally got the 3/4 necessary, after it was revived by a University of Texas graduate student who was annoyed about something that a professor said about it being a dead letter. Literally. Most amendments in the modern era that have been proposed have had time limits, but some of the earlier ones, including this one, did not. That's the 11th of the 12 that Madison proposed. There's still one out there from the original Bill of Rights. The one unsettled Madison amendment that's technically still pending, I would advise against you people adopting. It guarantees one member of Congress for every 40,000 people. If it had been adopted, Congress would be over 8,000 members today. Imagine the gridlock. I got a lot more to say, but I've taken a lot of your time. So why don't we take a 5-minute break, and then we'll talk about whatever you'd like.
Okay, everybody, if you could take your seats, we'll get started with the questions, and I'm sure you have lots of them. My name is Barbara Seitley. Some of you may remember me from previous candidate forums for the League of Women Voters. So I'm here to take your questions, and who wants to start? Don't be shy. Okay, up there. Yes.
Do you happen to know how the states originally got the borders they did? Because why would there be a giant state like Massachusetts and a little state like New Hampshire? Why would that have been done?
Her question is, How did the borders of the various states get determined?
I mean, I'm not an expert on this, but if I remember my grad school, it is some combination of colonial charters and grants of land made by kings to various people that were imprecisely defined and then were fought out between various individuals in various states in a series of land disputes that involved surveying, political back and forth, negotiation, and occasional actual skirmishes. The magic of the one major legislative achievement of the Articles of Confederation, which was the Northwest Ordinance, was that it protected us from having to go through that every time we expanded west. That it came up with a series of procedures for setting boundaries, for territories incorporating themselves. That's why all the boundaries out west are square, right? We're not all of them, but quite a lot of them. Yeah.
Are you saying we're all square, Henry? Okay. Who else? Yes, in the back row.
Is the Electoral College addressed in here, or will you talk about that on a different night?
Let's address it now, but because the text on the Electoral College came out of tonight's lecture, but it also is in the plan. It's relevant for the third, but let's talk about it a little bit now. The Electoral College, in the original design, was, well, they wanted Congress to elect, they wanted the states to be represented in the selection of the president the same way they were represented in the selection of, they were represented in Congress, because they'd reached a compromise that all the states were willing to abide by. In many of the early drafts, Congress picked the president. The problem was that they were worried about the president becoming too dependent on Congress, too dependent on Congress's favor, particularly if the president was eligible for re-election. So at one point, it was a 7-year term with no eligibility for re-election. They did a lot of things. They decided that they didn't want Congress to pick the president for separation of powers reasons. So they needed a body that had the same representation, and that's how you get the numerical representation in the Electoral College. They didn't think about political parties. In fact, they thought political parties were factions. They were one of the causes of the decline of other republics. They didn't want to have them. They lost that battle within 5 years. But in a world without political parties, where states mattered a lot, regions mattered, what they thought was going to happen was Washington would get unanimously elected, which he did, serve as long as he wanted. When he was done, each state or region would nominate a favorite son candidate. The Council of Elders that was the Electoral College would get together, would think about who was good, would fracture in a million different ways, but would effectively nominate the top 3 vote-getters to Congress, which would then pick among them. They didn't think anyone was going to get a majority in the Electoral College. And in the absence of political parties and nominations, they might have been right if it was just either a merit selection or a popularity contest. So that's how they envisioned things were going to work. Didn't work out that way. Once we had political parties, everything about the system was wrong. They came up with the 12th Amendment to fix that. The 12th Amendment has the candidates running on tickets, is now envisioning that we'll have a couple of parties nominating people. At that point, the Electoral College now becomes a balancing of state interests, right? Big states versus small states. They're still committed to that because they're still committed to the compromise between the big states and the small states, but it loses most of its other meaning, most of its other functions, becomes just a way for accounting between big states and small states. And you can see how that plays out. I think on balance, my personal opinion is on balance, it's negative. On balance, it makes voters in some states much more influential than voters in other states. It distorts governing towards those states in a variety of ways. It's undemocratic in some ways. But there are arguments in the other direction, and people who believe that, who believe that passionately. And that compromise between big state and small state was, one of the original compromises in the Constitution. So happy to talk about it further, but that's.
Yes, the gentleman here, and then in the middle, up there, yes.
Can you tell us the difference between separation of powers and checks and balances, or is there one?
It's a good question. Separation of powers. Separation of powers is the idea that all governmental functions have kind of a proper place for which to rest, and that each branch has a function to perform, and it focuses in on the idea that there shouldn't be much overlapping between the branches, too much interference in each other's function. Checks and balances normally comes to describe the idea that there should be formal mechanisms for each branch to do something about it if any of the other branches steps outside of its normal area. So separation of powers is the normal functioning. Checks and balances is what happens when someone goes rogue. But there's a lot of overlap between the two.
Yes, in the center there, in the top row.
I was just wondering if you have thoughts on the idea of the possibility of 2/3 of the states deciding that they wanted radical changes, and what in an environment when a good many of 2/3 of the states might turn out to be conservative in their leanings, and are there implications for that in the Constitution?
Yeah, I mean, the Constitution has two methods for amendment to fill people in who are not as far along in this part of the conversation. The only one that's ever been used is the one in which 2/3 of Congress propose an amendment to the states, and then 3/4 of the states have to ratify it. But that was actually the afterthought mechanism. If you look at Article 5, which is the amendment provisions, on the application of the legislatures of 2/3 of the several states, Congress shall call a convention for proposing amendments, and then gives mechanisms for approving those as well, either through the legislature or through convention of the people. So you could call, if enough states call for it, you can call a constitutional convention. Now, that constitutional convention would probably be limited in its call, or could be limited in its call to particular subjects. But if you get anything out of my lecture, you should get the idea that it doesn't always work that way, right? That once you have a constitutional convention impaneled, it can take a life of its own. And there's real danger in the idea of a constitutional convention. Depending exactly on the politics of the various states and the makeups of state legislatures and things, we're in a position where you could imagine, wouldn't be very hard to imagine, a political force that represents roughly half the country, because of the way states work out and the way local elections are working out, having a supermajority in a constitutional convention. It is the right wing that's been calling for a constitutional convention. And with, hundreds of modern day wannabe Alexander Hamiltons and James Madisons and George Washingtons running around, you worry about the forward thinking of this. So could the Constitution use amendments? Absolutely. Would a convention be an efficient way to do that if properly done? Maybe. But I agree with the implication of the Constitution I agree with the implication of the question that I'd be more worried than excited if one were called.
Yes, in the second row.
So, throughout history, Rhode Island has been hesitant to ratify federal legislature? What has been their reasoning behind this?
What's the question?
The question is that Rhode Island was hesitant to ratify or attend the convention in the first place. And what was the reason behind that?
Yeah, Rhode Island had a combination of small state concerns about being trampled. It was right next to Massachusetts, which did a lot of trampling at the time. But Rhode Island had small state concerns with very democratic politics. So was deeply concerned about people being overrun by capital and kind of shockingly modern concerns about big banks and things like that. So Rhode Island was just very skeptical. It's funny. I made fun of Rhode Island here. I could have just as easily made fun of South Carolina. One of my favorite professors in college, who was an Israeli historian, an American historian of early America, who was Israeli, so kind of a foreigner's perspective, said that when he was in school, when they asked you a question, what is the only state who blank? Up to 1800, the answer was Rhode Island. From 1800 to the Civil War, the answer was South Carolina. And since then, it's been Mississippi.
Yes, in the second row.
Well, I've heard that the word God doesn't appear in the Constitution, and that wasn't by accident. It was hotly debated at the time. Is that true?
Question, Barbara?
The word God is not in the Constitution. It was hotly debated at the time, and is it true?
I don't actually know whether there was a debate specifically about keeping the word God out. That I know it doesn't appear. I know that there were very different views at the convention about whether the convention should say much about religion. I guess all it says is no religious oaths for federal offices or honors, because the First Amendment isn't added until later. It is absolutely true that the vast majority of the founding generation, almost uniquely in early America, more so than the people before them and the people after them, wanted minimal relationship between formal religion and the state. Some of them to protect the state from religion, some of them to protect religion from the state. But it was a quirk of that generation.
Yes, way up in the balcony over there.
You talked a lot about the 14th Amendment. Can you give a fact pattern so the audience can understand the application of the 14th Amendment as it related to the real world?
Absolutely. The 14th Amendment has 3 operative clauses, and this is where my editing cut me at short shrift. The 3 main parts of the 14th Amendment are no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. The first of those, the Privileges and Immunities Clause, they spent the most time on, thought was the most important, and in one case that I mentioned in 1873, the Slaughterhouse case, the Supreme Court effectively sliced it out of the Constitution. But the other 2, the one saying you can't take life, liberty, or property without due process of law, nor deny to anyone within a state equal protection of the law, the due process and the equal protection clause have been the subject of immense, hugely important litigation. The equal protection clause is where we fought out such things as school segregation, same-sex marriage, exclusion of women from military academies, like Virginia Military Academy, the basic questions of what kinds of lines can government draw. The Due Process Clause has 2 main lines of cases. One line of cases is about what procedures the government has to give you when they want to take something away from you. So they want to take away some sort of welfare benefit, do they have to give you a hearing? They want to take away your government job. When do they have to give you a hearing? What kind of notice? What kind of explanation of the reasons? In the immigration context, do you have to be able to call witnesses before you're excluded from the country? Do you get an interpreter? Those procedural questions. It is also often, but not always, and we'll talk about this in the next lecture, been interpreted to have a substantive component, for there to be certain kinds of laws that government can't make, no matter how much procedural protection they give you. So questions like, can government bar certain groups of people from getting married? Or tell you you can't send your kids to private school, you have to send them to public school. Or tell you you can't get an abortion. Or criminalize same-sex sexual activity. Those have been fought about under substantive due process, which is one of the 14th Amendment provisions.
Yes, right here, in the blue sweater.
I'm fascinated by this whole concept of slavery in that constitutional time. First question is, how much were these founding fathers influenced by the Enlightenment? And the second question is, this assumes you were there, but how hotly contested was the issue of slavery among those founding fathers? And how much did morality come into their discussion? Do you know about that?
Yeah.
Okay, the first part of the question is, how much were the founding fathers influenced by the Enlightenment? The second is, how hotly contested was the issue of slavery? And the third is, what the morality of the slavery issue.
Okay. On the first question, most of the founders considered themselves men of the Enlightenment. What they meant by it, what they took from it, was different from person to person, might be different from what you and I take from it. But they consider themselves heavily influenced and as creatures of the Enlightenment. It's where they get a lot of their inspiration for remaking institutions. With regards to slavery, we have good sources. They wrote a lot about it outside the convention, and we have various notes on the convention. They talked about it a lot. The founding generation understood, not everybody, but a lot of people, including a lot of the Virginians, a lot of some of the other Southerners, understood the tensions between the rights that they were claiming and the institution of slavery. I mean, the Massachusetts Supreme Court outlaws slavery between the Revolution and the Constitutional Convention in a very modern-sounding decision that basically says it's inconsistent with the every person is created equal type language in the Massachusetts Constitution. A lot of the founders who owned slaves claimed that they were going to free them in their wills. Very few of the signers did. Ran up debts, couldn't do it, whatever else, made other choices. But slavery is defended in practical terms. It's defended in terms of peace among the different colonies. It's defended sometimes as a necessary evil through the 1820s. The turning point is late 1820s, 1830s, where southern states become entrenched with the institution for a variety of complicated cultural and economic reasons and begin to develop an ideology that slavery is a positive good. But until then, the delegates much of the country is wrestling with slavery as an institution that whatever you're going to do about it is a moral problem of some kind. I mean, in 1828, the Virginia Constitutional Convention drafting a new constitution comes within 10 votes of banning slavery in Virginia. You think about that.
Yes, in the blue sweater there.
So I'm sure you'll get to Citizens United when you get to the Supreme Court. But what were they thinking or not thinking about how money would influence the politics of the country?
Citizens United, what were they thinking or not thinking
For those
when
who
they
don't,
made that decision?
For those who don't know, Citizens United is the decision, going on 5-10 years ago, in which the Supreme Court strikes down spending limits for corporations in political campaigns on the grounds pretty much that corporations are fully protected by the First Amendment and that none of the justifications offered meet strict scrutiny, meet the high standards of the First Amendment. A lot of political opposition to that. I think that I'm going to make everybody unhappy here. I think Citizens United is wrongly decided, but on much narrower grounds than most people usually object to it. Most people object to it on the grounds that corporations couldn't possibly have, they're not real people, they couldn't possibly have rights. They couldn't possibly have First Amendment rights. And rightly or wrongly, the tradition of giving some rights to corporate entities, to fictional people, goes under the 14th Amendment and the other amendments, goes back at least into the 1870s. And there are some good reasons for it. You would worry about a lot of things the government could do if just because you were in a corporate form, they didn't have to protect your basic rights. I think that the two major failings of Citizens United, one is that it just misunderstands entirely the history of the corporate form in this country. The corporate form has historically been a special, we now have general incorporation statutes, but it was originally a special privilege where you got limited liability in return for taking certain limitations, and it is a choice. You don't have a right to the form, and if states or other entities who are creating corporations want to limit the kinds of activities you can engage in to things that are closer to the core of the corporation that don't involve political spending in order to get the nice benefit of limited liability, then I think that that's permissible in our constitutional tradition. And I also think that Citizens United totally butchers the strict scrutiny analysis where it assumes that there's no significant corruption problem.
My question was, what were the founders thinking? I'm saying you were going to get to that, but what were the founders thinking about money in politics?
The founders were not really thinking about modern politics at all, because their vision of politics, most of the idea of even actively campaigning, of popular campaigns, of really trying to convince the people of something, let alone political parties and stuff, are coming at that moment and afterwards. So they don't envision modern politics, and as I said, they don't really envision the modern corporation. If the question is, did they think that people who had a lot of money should have a big role in politics, though, the answer is yes. They were big money people who expected, but they expected it through deference and the same kind of natural processes that that led elites to govern in the colonies and led elites to govern in England, not by, buying all the newspapers.
Okay, we have one right here and one back there, and then I think we're going to have to wind up because I think our rental contract runs out at 9:30. And I want to remind you all before you go that there are constitutions available, the copies, on a table out in the lobby, and you're welcome to pick one up on your way out, and I hope you will. So the gentleman in the front row here has been waiting a long time.
I'm wondering about, in the formation of the Constitution, was Native American government of any particular influence on the founders themselves and ultimately then on the Constitution?
The question is about Native American government, and did it have any influence on the founders themselves or on the writing of the Constitution?
In making arguments for the different kinds of constitutional structures that worked or didn't work, they drew most heavily on Roman experience, English experience, Greek experience, but many of the pamphleteers of the time and the leading founders were extremely well read And there are certainly places in some of their writings where if they're making a point about a particular structure, something that the Iroquois Confederation did or somebody else did pops in as an example in kind of the same way that like a Swedish canton might, but didn't have, or a Swiss canton, but it didn't have any particular relevance because of its presence on this continent or because they felt any sort of duty to honor or respect those institutions.
Yes, sir.
Yeah, I read recently that there's 2 bills in the Senate to try to further the ERA along, and I wondered what the gymnastics politically would be to get it passed in 2, 4, or 8 years.
The question is about the ERA. He understands that there are 2 bills in Congress that would move it along, and he wants to know what the process would be.
Yeah, the ERA, I assume everyone knows, is the Equal Rights Amendment meant to prohibit discrimination on the basis of gender, passed overwhelmingly in the 1970s by Congress, sent to the states, quickly gets within a couple of states of ratification without any significant opposition. Opposition develops, for reasons we could talk about, and stops the momentum dead in its tracks. There's kind of a weird interplay with the Supreme Court, where the Supreme Court is at the same time considering gender-based equal protection challenges to a variety of things, and they're very close to adopting strict scrutiny and making gender discrimination the same, as invalid under the Constitution as race discrimination. Lewis Powell famously withholds the fifth vote, saying it would be much better if we did it democratically through the Equal Rights Amendment. But what they do adopt kind of also helps stem the push for the Equal Rights Amendment, saying, well, there's close enough to equality through the courts. It is an issue that has been surprisingly silent politically in the years since. Occasional attempts to jumpstart a movement, but maybe now is a moment, a lot of people think, for a variety of fairly obvious demographic and political and generational reasons. The bills that are out there now are not new versions of the ERA, which you could pass through Congress. You don't have the votes, but you could take through Congress. They're complicated attempts to extend the deadline of the prior ERA. There's a Supreme Court decision interpreting a prior attempt to extend the deadline of the ERA that stands as a potential legal hurdle. But the ERA, like most amendments that haven't been passed, unlike the 40,000 member of Congress amendment and a couple of others, has a deadline built in that has passed. Again, the reason why those bills exist is you only need a majority in Congress rather than two-thirds in Congress to send those out. But the legal hurdles really are hard for extending. It's one of the things that I'm optimistic about in the world, which is, given the pattern of constitutional change on other issues, I find it absolutely impossible to think that at some point there won't be an ERA in the Constitution. But, I've been saying that for a lot of years, and we seem to be getting further, not closer to that. So,
I want to thank you all for coming and for participating this evening.